Hello, this is John Miller, founding attorney of Rock Solid Law and Rock Solid Title, celebrating our 30th year, which is pretty darn exciting. This morning, we are here to talk about the Florida Realtor's Guide, Glovebox Guide to Real Estate Title. It can be kept in the glove box, it can be kept in the trunk, but it's a handy dandy little pamphlet that we came up with sort of as a cheat sheet to our realtor friends about how people can take title. Imagine yourself with a buyer and you've just about got a deal closed, and they've agreed on price. They agreed they love the place you've showed them, and they turn around and look at you and say, "But how shall we take title? What's the best way in Florida? I'm coming from the Midwest, or I'm coming from the Northeast. Tell me about my options for taking title in Florida." So you, having trained amazingly in real estate, and many lawyers as well who don't do, I call it sand law, dirt law, real property law regularly, don't stay up to date on the various manners in which title can be held, and there are a lot of them. So it's more than any one person typically, other than a real estate lawyer, would keep right at their fingertips. So you hand them or pull out your handy dandy glove box guide to real estate title for Florida realtors. Okay. We created this for our friends in Northeast Florida, so you'd have it at your fingertips at any point in time. This morning, I'm just going to walk you quickly through it. This is available. Call my office, 904-241-1113, and let my team know how many copies you would like to have, or send us an email. Same thing works. Anything at rocksolidlaw.com. Questions at info at or any member of my team that you know at Rock Solid Law. We'll get those right out to you. So what's inside this thing? It's a trifold, right? So it's going to fold just up like this, fold out like this on the left side. So it's something you could actually give to a customer if you wanted to. It's deciding on how to hold title is a really, really important decision. And how the new buyer will take title is going to affect all the manner in which that title is held and transferred in their lifetime. So, as I said before, the inexperienced buyer is going to lean on you to help them make that decision. There can be serious legal ramifications if you get it wrong. So, I recommend always bringing in a real estate lawyer, such as myself or one of my co-counsels around Northeast Florida who do a good job to address the issue. Um, so too many people think of real estate closings as cookie cutter. They're just not. And the buyer will be well served to discuss all of the various options with an attorney. Right now, I'm doing a large residential transaction for a couple coming in from out of state. So many are during the pandemic. And I'm just delighted. I just got an email from another one of my brothers at the bar, I'll say, an excellent real estate lawyer. And I'm actually excited that we've got a deal to work on together, because it means we're in touch, and he and I hadn't spoken in a long time. Great to have lawyers on both sides, just like it's great to have quality realtors on both sides of a transaction. So number one, sole ownership, right? That's just a single person owns a property. This can be a person who is unmarried, right? Obviously, but it could also be a married person owning non-homestead property. If there's an issue about a married couple and one of them wanting to own homestead property alone, I'd specifically urge you to get a lawyer involved in that situation so that we can explain the Florida Constitution, homestead law here, and the choices that they're making. So that sole ownership doesn't afford any tax or estate planning benefits at all, but it is the simplest way of owning property. When that owner dies, the property will go through probate and will subject itself to all of the costs, expenses, uncertainty, and tax of a probate proceeding. The next one is I think the most common, a very, very common form, particularly for homes, and that is tenancy by the entireties. That can only be enjoyed by a married couple. So that's why you see on a deed a married couple, or wife and husband, or husband and wife. identifying them, and you rarely see actually the words tenancy by the entirety typed out on a deed. So when you see that husband and wife, or indicating that they are a married couple, you know that that is tenancy by the entirety. So that cannot be severed from between the two parties for as long as they are alive and remain married, right? If there is a divorce, it'll be split up by the order of the court. And if one of them dies, it automatically goes to the other one. If you'll think of it this way, each party owns 100% of the property. Each party owns 100%, right? And that's indivisible. So that if one dies, the other one automatically owns the whole thing. So it does also create additional protections for that married couple. For instance, a creditor of one spouse cannot attack the tenancy by the entirety, homestead or not. Okay, so homestead will, of course, come into play, and there are other videos in our library on homestead in the event that there is a creditor of one or both of those spouses. The next one, okay, joint tenants with right or survivorship. We just call that JTROS. And this is very similar to tenancy by the entireties, but is for someone who is not married, right? So just two people that want to own property together can hold title together. And if one of them dies, the ownership automatically transfers to the remaining owners. Why is this something different than tenancy by the entirety? Because it's for people that are not married to each other. Any people, for instance, it'd be useful for a couple that's living together but chooses not to be married if they wanted to own their homestead in this manner. Each owner owns equal shares. Again, I think of it as 100% ownership because it's non-transferable without the cooperation of the other. The other manner of holding property that we often see come into play is tenancy in common, which allows each party to own a percentage of the property, not 100%, right? So it's often 50-50. The thing to think about is it must be designated on the deed specifically whether it's equal shares or they're in unequal percentages. I highly recommend a competent real estate lawyer be engaged in the event parties wish to hold title by tenancy in common. Tenancy in common. Tenants in common leads to many, many disputes. But this is the way, for instance, people get together and want to invest in a property together, right? Some friends, business acquaintances, and they can put up how much each is going to own. So each owner is able to pass his or her share to another person, right? So they can sell or transfer their ownership percentage to someone else without the permission of the others, right? So it can be an advantage, each wanting to pass theirs on to their heirs or to other people. It can also be a disadvantage because you can end up owning property with a complete stranger or someone you don't like very much. So that's something to take into consideration there. The other thing is asset protection. Each owner's creditors can levy a judgment against the property. If one of the owners has a creditor, is potential that a sale could be forced. Okay, those are probably four of the most common areas, and they are all outlined in the Florida Realtor's Glovebox Guide to Real Estate Title, which folds up and fits really neatly into your glove compartment or your trunk, if you prefer. I also let you know where our office is and what our areas of expertise are, because in addition to real estate, we do estate planning, and you've heard estate planning discussed throughout these various manners of holding title. And we also do small business representation, which segues very well into other ways property can be held. One, especially if there are investors involved, that's very, very common is to own the property in a limited liability company or LLC, which has its own considerations. And I would urge you, realtor, to advise your customer or client to seek advice on getting that LLC set up properly for asset protection. I will tell you, of course, everybody knows you can go online with the vendor for the Secretary of State and form an LLC, but the likelihood of that LLC getting formed properly and ending up protecting the assets in the manner in which the customer client intended is remote. And we are often called upon to fix those errors, and it's more expensive to fix it and time consuming as well than it would have been to get it right in the first place. Oh, as I say every week, I've got a few more to hit, manners of ownership, but if there are any questions, please use the chat screen to let me know. So in addition to LLC, other business entities are available. You know, before 1999, we didn't have LLCs in Florida. And there are issues with sole ownership and asset protection today. It's funny because in the first years, sole ownership was disallowed in Florida. So there was a big hole there, and it eventually got closed. Now, liability and sole ownership becomes an issue for us again. Another way of holding property is through a partnership, limited liability partnership, multiple different kind of partnerships out there available. The LLC may have closed off the need for using those, but sometimes they still do come into play as an excellent way for parties to hold title together. A land trust, a Florida land trust, was regularly used for holding title really prior to the era of the LLC, but with the asset protection issues currently involved in an LLC under Florida law, we are seeing the rise of land trusts again. So it's something which people may want to look at. Of course, a sub-S corporation can be used if it is preferable for some particular reason, particularly to the transaction. In addition to a land trust, it is not uncommon for people to hold property in other trusts. There are various reasons why they might want to hold property in a trust, including the homestead being in the revocable living trust for ease of transferability on the second death. Be glad to discuss that with anybody. But then if there's asset protection issues, you may want to consider an irrevocable trust for that piece of real property, which could keep creditors at bay. And then finally, I wanted to address the possibility of foreigners in ownership, which does require special consideration. And if you've got that situation, you really want to get the parties to a lawyer as quickly as possible so that they can discuss the manner that they will be holding title. Folks, that really wraps up my discussion of the manners in which title can be held, and to just once again reiterate that we have the Glovebox guide available for you. Next Thursday, I'd like to let you know that we will be talking about back to the estate planning field, taxes and changes. Of course, we're looking into our crystal ball, and taxes and changes which may take place or that are expected to take place or that people are discussing may take place in light of the new administration, which has taken over the government of the United States of America. So that should be a really, really interesting discussion next week. I think it's taxes aren't always the easiest to make palatable to discuss, but we try to discuss them in common language and help you out. So today's main point is that the Florida Realtors Glovebox Guide is available to you. It's free, by the way. We want you to use it in your real estate practice, and we want you to remain safe and healthy out there. This is John Miller, founding attorney of Rock Solid Law in Jacksonville, Florida. And we hope that this real estate market remains strong for a long time for all of you out there, and that our Florida Realtors Glovebox Guide to Real Estate Title will help you be the superior realtor that you are. Thanks, everybody.